Hello and welcome to Spardha Lines, your one-stop destination for the civil services preparation, UPSC, KPSC and other relevant examinations. Today we have picked up some of the important articles and MCQs which are very relevant for your UPSC examination as well as your KPSC examination. Let's get started and look into the first MCQ and the first article. With reference to palm oil, consider the following statements. The palm oil tree is native to Southeast Asia. The palm oil is a raw material for some industries producing lipstick and perfumes. The palm oil can be used to produce biodiesel. Which of the statements given above are correct? The answer to this is 2 and 3 only. Why have we taken this practice question? Because this article on the Hindu makes a reference to palm oil imports. So remember, this palm oil imports and the production of palm oil is very important from your GS paper 3 economy article. What is it about this practice question? When you look at the previous year questions, this was one of the previous year questions that was asked in UPSC. So of late UPSC is coming up with some of the important parameters with respect to how international relations work, what are the kind of imports and exports that takes place between one country and another, what is the current account deficit, what is the twin deficit and how is it molding the Indian economy. These are some of the factors which the Indian government is keenly watching on. Why? That is because of the changes that we have introduced in our internal structure. We are bringing some of the major changes when it comes to our economic structure as well. Since the government of India is focusing on the structural aspect and its changes, this part becomes very important from the UPSC examination point of view. And whenever there are major agreements that takes place between one country and another, you have to know what are the exports and imports that are also relevant from the examination point of view. Since the government of India is focusing more on Atmanirbharata, indigenization, India has also come up with some of the measures where we are planning to make sure that we do not have much of imports of palm oil. So that is why palm oil becomes one of the important factors when it comes to UPSC examination point of view. Let's discuss some of the important parameters with respect to the palm oil. Palm oil is an edible vegetable oil derived from mesocarp, which is nothing but reddish pulp of the fruit of the oil palms. The oil is used in food manufacturing, in beauty products and as a biofuel. Palm oil accounted for about 33% of the global oil produced from oil crops in 2014. Palm oil are easier to stabilize. They maintain quality of flavor and consistency in foods and so frequently are used by the food manufacturers. The biggest producers of palm oil are Indonesia, Malaysia, Thailand and Nigeria, and Indonesia produces biodiesel primarily from palm oil. So if we look into the practice question right now, the first statement is wrong. Why? That is because the palm oil tree is native to Southeast Asia. No, it is native to Africa. So the first statement is wrong. And when you look into the second statement, the palm oil is a raw material for some industries producing lipstick and perfumes. Yes, that is the right statement. We did just look into it. The third statement is also right, that palm oil can be used to produce biodiesel, and as we just discussed, Indonesia makes use of the palm for production into the biodiesel as well. So the first statement is wrong, second statement and third statement are right. So the answer to this would be 2 and 3 only. In order to promote palm oil, what is that the government of India is engaging with? The government of India has come up with a program called as the National Mission on Edible Oil and Oil Palm. So during the year 2021, India imported 133.5 lakh tons of edible oil, out of which share of palm oil was close to 56%. Mind you, it is more than 50%, in order to ensure that we do not import much of the oil and also make sure that we have our own program. The government of India came up with the National Mission on Edible Oils, Oil Palm, which has been launched with an aim to augment the availability of edible oil in the country by harnessing area expansion, which is to make sure that if the area that is currently is around, let's say 1000 hectares, this will be further expanded. This will be increased to about 1500 hectares, hypothetical numbers. So the idea is to increase the area under which palm oil is grown, then increasing crude palm oil production with an aim to reduce import burden. So the major intent of coming up with this particular program is to reduce the imports from couple of countries world over. For example, we are making sure that we do not import it from Indonesia, we do not import it from Malaysia, we make sure that we have our own products in place, and that happens to be the major salient feature of this program. The salient features also include assistance for planting material, inputs for intercropping up to gestation period of 4 years and for maintenance, establishment of seed gardens, nurseries, micro irrigation, borewell pump set harvesting structure, vermicompost units, solar pumps, harvesting tools, customer hiring center cum harvester groups, farmers and officers training, and for replanting of old oil palm gardens. These are some of the measures that have been taken in order to reduce the imports from some other countries. So what is the intent? The intent is to make sure that we reduce the oil imports. What does this article say? India's palm oil imports jumped 29.2% to 90.8 lakh tons in the first 11 months of the ongoing 2022-23 oil year compared with the year earlier period. So this also says that oil imports has increased over a period of time. But the major aspect is what we just discussed with respect to the oil imports. Now let's look into the next article. This question is picked up primarily because we have one of the articles with respect to the CAG, the Comptroller and the Auditor General. The duties and powers of CAG in regard to the accounts of the union and state governments are laid under Article 149 of the Constitution, Article 150 of the Constitution, Article 151 of the Constitution, Section 10 to 12 of the DPSC Act of 1971. The duties are defined under which of the following articles and the sections? The answer to this is 1, 2 and 4 only. Why have we taken this practice question? Because this article on the Hindu makes a reference to CAG, which is why we have taken this practice question. When we look into the Constitution of India, the Constitution of India speaks about the Comptroller and Auditor General. We have Article 148, 149, 150, 151 which all speak about the Comptroller and Auditor General. But what is the question looking at? The question is looking at the duties and powers of the CAG. Does Article 151 speak about the duties and powers of the CAG? No, because Article 151 speaks about the audit reports. So what are these audit reports? Whenever you have the Comptroller and Auditor General, what is the function of the Auditor General? Basically, there is a program of the Government of India or the respective states. Whether this particular program that is envisaged by the Government of India or by the respective state, is it in according to the modalities and the principles that have been laid down by that particular missionary or by that particular ministry? If it is spent in a right way or wrong, how is it spent? Is there extravagant spending? Someone has to audit the accounts of a particular ministry as well as a department. So who will do it in India? It happens to be the Comptroller and Auditor General who will audit the report of that particular program or the policy or any initiatives taken by the respective departments. So the reports that is ultimately taken up and posted before the President is the audit report, and that is what is discussed under 151 of the Indian Constitution. Does it speak about the powers? No. This ultimately means that the reports of the Comptroller and Auditor General of India relating to the accounts of the of the Union shall be submitted to the President. Whom is it submitted to? It is not to the Parliament, remember. It is submitted to the President, who shall cause them to be laid before each house of the Parliament. The reports of the Comptroller and Auditor General of India relating to the accounts of a state shall be submitted to the Governor of the state, who shall cause them to be laid before the legislature of the state. This is what Article 151 speaks about, and we have a major law in the form of a statutory backing called as the Comptroller and Auditor General's Duties, Powers, Conditions of Service Amendment Act of 1971, which is nothing but the DPC Act. Yes, the DPC Act has the powers of it, so it has major powers in the form of Article 10 to 12, and that is why we have taken this practice question. We have other major articles as well. What are the functions of the Comptroller and Auditor General? There shall be a Comptroller and Auditor General of India who shall be appointed by the President by warrant under his hand and seal. Now I would give you an assignment. What does it make a mention of? It says appointed by the president by warrant under his hand and seal. Which are the other authorities which are mentioned as part of the constitution, which are given appointed by the president by his hand and seal? Which are these other authorities? Please put it on the comment section. Shall only be removed from the office in the manner and on the like grounds as a judge of the Supreme Court. First important parameter. And every person appointed to be Comptroller and Auditor General of India shall, before he enters upon his office, make and subscribe before the president or some other person appointed in that behalf by him on oath or affirmation according to the form set out by the purpose in the third schedule. So in which of the schedules do we have a mention of the KAG? There might be another practice questions that could be asked. So remember, it finds a mention in the third schedule. Is it finding a mention in the second schedule? Yes, as well. The salary and other conditions of the service of the Comptroller and Auditor General shall be as much may be determined by the Parliament by law until they are determined so shall be specified in the second schedule. So this KAG finds a mention in second schedule. It also finds a mention in the third schedule. Another important prospective question from your UPSC examination and KPSC examination point of view. They can ask you a question: in which of the following schedules do we have a mention of the KAG? First schedule, second schedule, third schedule, fourth schedule, so on and so forth. So it finds a mention in the second and the third schedule, which is very important. And the Comptroller and Auditor General shall not be eligible for further office either under the Government of India or under the government of any respective state. So once he is appointed as the governor, he shall not be entitled to become part of the, once he is appointed as KAG, that is Comptroller and Auditor General, he shall not be eligible to be appointed on any government offices. For example, if he wishes to continue in any of the other government offices, he would not be able to do so. That's the restraint that has been laid. Subject to the provisions of Constitution and of any law made by the Parliament, the conditions of service of persons serving in the Indian Audit and Accounts, administrative powers of the Comptroller shall be such as prescribed by the rules made by the President in consultation. So the rules will be in consultation with the Comptroller and Auditor General. The administrative expenses of the office of the Comptroller and Auditor General, including all salaries, will be charged upon the Consolidated Fund of India. So whose salaries are charged upon the Consolidated Fund of India? For example, the Supreme Court judges. So these are the people whose salaries could not be changed according to the vagaries of the executive. Why is it done so? Let's imagine a moment where you have the KAG who has to work independently, or let's take the example of Supreme Court of India. If their salaries depends on the whims and the fancies of the executive, all the judgments of the Supreme Court of India and all the important decisions made by the Comptroller and Auditor General will reflect primarily on the whims and fancies of the executive, primarily because what if they don't get their salary? They should get their salary, right? They should be able to live their livelihood. They should be able to perform their daily activities. So if all of this is dependent on whether the salary is being credited by the executive or not, they would not be able to work with full faith. They would not be able to execute all their work as well. In order to prevent it, so that it does not depend on the whims and the fancies of the executive, let's charge it on the Consolidated Fund of India. So even if the executive wants to change, they would not be able to change it because it is charged on the Consolidated Fund of India. So they would be able to think independently, act independently without any pressures or whimsies from the executive. So there are few offices like the Supreme Court judges, High Court judges and the KAG, which is charged upon the Consolidated Fund of India because they need not have to depend on the executive for the salaries. Such officers which are given complete independence so that they can act independently without any external pressure, one such office comes under the Comptroller and Auditor General, which is charged upon the Consolidated Fund of India. What does Article 149 say? It speaks about the duties and powers of the Comptroller and Auditor General. The Comptroller and Auditor General shall perform such duties and exercise such powers in relation to the accounts of the Union and the state of any authority or body as prescribed by under any law made by the Parliament until provision in that behalf, shall perform such duties as in relation to the accounts of the Union and the state as conferred exercised by the Auditor General of India immediately before the commencement of the Constitution. So we have Article 149, which says that we have the Parliament has certain laws, and these laws will define what are the powers and the functions that are given to the Comptroller and Auditor General. The accounts of the Union and the state shall be kept in such form as the President may, on the advice of the Comptroller and Auditor General, prescribe. So these are some of the functions with respect to the Comptroller and Auditor General. Now let's look into the next article. This article says, Supreme Court imposes 5 lakh fine when frivolous public interest litigation dismisses plea on evolution theory. This article is important from your GS paper 2, which is primarily from Indian polity. First, we have to understand the concept of public interest litigation. What is this public interest litigation? We have to understand another concept called as the locus standi. What is this concept of locus standi? Let's say, for example, there is a property dispute between me and you. So what do I have to do? Is it the state that is involved in this particular case? No, it is a dispute between me and you. So who has the locus standi? Since I have my right which is violated by you, so I have every right to seek and go before the court of law and ultimately say that, dear court of law, my right which is getting violated because this person has trespassed into my property, interfering with my personal property. I am not able to enjoy the rights of my property. So please give me a conclusion, please give me an order, please pass a decree saying that this property belongs to me. So what do? I go before the trial court, I file a plaint, and ultimately I give all the evidences that I have, and I also bring the witnesses as well, and ultimately the court takes a conclusion and ultimately gives in favor of one of the parties. So who has the locus standi? Locus standi is one particular principle to define and alert a particular person that his right is getting violated. So if my right is getting violated, I will file a case. If your right is getting violated, you will file a case. Whosoever that person's right is getting violated, only that person will have to file a case in the respective courts. It can be the trial court, it can be, let's say, for example, in the High Court under 226 of the Indian Constitution, or it can be under Article 32 of the Indian Constitution, which speaks about the fundamental rights as well, in the Supreme Court of India. So only when a person's right is getting violated, that is when he would be able to go to the court of law. So the locus standi means there is a right that is violated. I would be entitled, I have the right to go before the court and seek for a remedy and a claim from the court of law. But what happens in certain cases is you do not require the locus standi, and that is where the public interest litigation comes into the picture. So earlier, prior to the 1980s, the Supreme Court and the High Court looked into only one parameter. Is your right getting violated? Are you the person suffering from it? Are you the person who is irritated by that particular contention? Only then you go before the court of law. So the locus standi, whether your right is getting violated, was an important concept before to 1980s. But after 1980s, what exactly happened? The Supreme Court started looking at a larger canvas. It said, yes, people's rights are getting violated, so locus standi is important, and they come before the court of law. But there is society as a whole as well. There are few people who are privileged. There are other sections of the society who are not privileged in the country. So in India, at the times of 1980s, most of the people were unprivileged sections. These people did not have the material, these people did not have money, these people did not have the larger leverage to fight against the system as well as against the judicial system, because the judicial system is a far-fetched dream for many people. Why? Because it involves a lot of procedures. It also involves hiring of some advocates as well. They also have to file these cases as well. They have to run these cases for many years as well. This was not possible for a certain section of the society. So at this particular moment, the Supreme Court started envisaging, why not come up with something called as a public interest litigation, social interest litigation, where people who do not have the locus standi, that is their rights per se, is not getting violated directly at that particular moment. Someone else whose rights is not getting violated, but he feels that a larger section of the society and the people, their rights are getting violated. in that particular moment he can file a public interest litigation. Let's say for example there is a particular area, I live in Bengaluru, but there is a problem that is occurring, let's say in Chennai or in my neighboring district, let's say Mysuru, or let's say in Mandya or any other district. So what do? I as a person who is living in Bengaluru, I feel that if this particular plant come in this particular area, let's say in Mandya or in Mysore, they can release a lot of waste into the Kaveri water, and ultimately the Kaveri water is used for irrigation purposes and also for drinking water purposes and also for agriculture. So this industrial plant should not come in Kaveri. I do not have a locus standi, but it is the people of Mysore and Mandya and many other districts who will suffer. So I will file a public interest litigation. So in this particular case the locus standi is not required. So until 1980 the Supreme Court only decided that if a person's right is getting violated, whosoever is that person whose rights are getting violated, only that person had the right to go before the court of law. But after 1980 the Supreme Court also realized that there are large number of unprivileged sections of the society who may not be able to fight a case in the court of law. That is when an alert citizen, an active citizen who is working for the country and for the welfare of the people, if he feels that there are unprivileged sections whose rights will also have to be restored, in that case they will file a public interest litigation. So this public interest basically means that a larger section of the people are suffering. They do not have the stand, they do not have money at their disposal, they cannot find the machinery as well. So at that particular moment I will step in and file a public interest litigation, that is I'll file a case before the court of law so that their rights are restored, is what is called as the public interest litigation. So a public interest litigation is for the larger purpose of the society, and this was also promoted by Bhagavati, Justice Bhagavati. So this is the simple concept of public interest litigation. So remember, there might be a question in your preliminary examination which will ask you, is locus standi required for the public interest litigation? The answer is a clear cut no. Now another question as we speak about this locus standi, we have habeas corpus case. A habeas corpus case once again does not require the locus standi. So there are other writs as well. We have certiorari, prohibition, so on and so forth, in which other locus standi not necessary, please put it on the comment section. We have habeas corpus, which happens to be one of the writs for which locus standi is not required, which is another writ for which locus standi is not required. Please put it on the comment section. So we know for the fact that public interest litigation has been taken up in couple of areas. Let's say for example, as we just discussed, we have let's say for example environmental related issues. We have MC Mehta versus Union of India, which happens to be a landmark judgment in the 1987, where couple of actions with respect to the environment has been taken up. Then we also have atrocities on the women. We also have maintenance on heritage and the culture. We also have food adulteration issues that are coming up. In all these cases, public interest litigation have been accepted by the courts in our country. But then what this article is primarily speaking about is with respect to the frivolous public interest litigation. So what happens is, in couple of areas, this public interest litigation has become the private interest litigation. How? Let's say for example, there is a state government which has come up with a plan to construct a road, a ring road. So outer ring road, in that particular place, the government of India decides that this particular road, if it has to pass through a particular area, they have to acquire a certain piece of a property. So what does the government do? The government says that this property owned by so and so person will be taken over. That is what is the intent, because the government feels that if this road comes into picture, it can reduce the congestion and the traffic in a particular area, and all these vehicles will have to move outside the city limits. So we require a ring road. So they will start acquiring a particular piece of land. The person whose land will be acquired will basically feel that this is a public interest litigation. Why? Because there is an agricultural property. If the government takes over this agricultural property, it will be harmful for so and so person. person. So ultimately he says that if this required land is taken for the construction of the road, it is violating the rights of the principal. Ideally, it is his own private interest that is coming into picture. Why? Because the government is acquiring this land and it happens to be his property. So instead of saying that it is his property, he brings in a notion saying that it is a public interest, that he is acting for a cause of a general public. So this is where private interest comes into picture. So one of the weaknesses of the public interest litigation is there are large number of frivolous public interest litigations that are filed, that is primarily private interest litigation. So we know for the fact that there is one of the doctrine called as doctrine of eminent domain. What is this doctrine of eminent domain? The doctrine of eminent domain basically says that if there is the government which feels that there is a larger purpose for the public and land will have to be acquired, for the land to be acquired, what we require is the public interest. So in the name of public interest, I would be able to take a piece of land for the public. For example, construction of the hospital, or for example the road, or for the defense purposes. How is the government able to acquire this land? That is through the principle or the doctrine of eminent domain. But then the government acquires it, but immediately, because there are few individuals who have a particular perception, they have their own interest in place, they file cases after cases in the name of public interest litigation, and it ultimately is violating a certain rules and regulations, and government call and Supreme Court or the High Court calls it frivolous public interest litigation, which means to say they are not supposed to have been filed, but they have been filed. And at the same time, when we speak about these weaknesses of the Supreme Court, when we speak about the weaknesses of the public interest litigation, another major weakness of the public interest litigation is with respect to judicial overreach. What is this judicial overreach? We have the separation of powers. The separation of powers being the legislature, the executive and judiciary. Who has to make the laws? It is the legislature. Who has to implement the laws? It is the executive. Who has to interpret the laws? It is the judiciary. When the judiciary, which has to just interpret the laws, enters into the domain of the legislature and starts making the law, that is what is called as judicial overreach, or there is a particular contour or a boundary to the judiciary, and the judiciary should only look at that particular boundary. If it oversteps the boundary, that is what is called as judicial overreach. What happens in most of the cases? Only when a case is filed, that is when the judiciary will have to accept it. For example, in this particular case, we did discuss about the private interest litigation. So instead of public interest litigation, it becomes the private interest litigation, and in this particular case, he files a case saying that the right of the society is getting violated when judiciary is stepping into such domain where public interest litigation takes the disguise of the private interest litigation. In that case, it could also lead to lot of delay as well. How lot of delay? When there are cases that are already filed, when there are cases that has to be taken into picture and has to be resolved by the judiciary, it does not take those cases. But here, where there is no locus standi per se, if these cases are taken up by the judiciary, the cases they should have resolved and these disputes should have been cleared are ultimately kept in pipeline, and these are not resolved by the judiciary, so there is delay as well. So on one side there is overreach. How overreach? Because the judiciary is stepping into the shoes and directing few things which should not have been done by the judiciary, that is overreach. And because there are cases that are already filed, these cases should have been looked into, but instead of looking into those cases, it is taking up public interest litigations, and ultimately there is delay that is caused to other set of litigants, and these are some of the other weaknesses of the public interest litigation. So weaknesses of the public interest litigation is where we have frivolous public interest litigation, and we also have judicial overreach, and there is delay because of these public interest litigation. These are some of the weaknesses. We did discuss about the advantages, that there are labor matters, then there are environmental matters. All these are taken into picture by the Supreme Court and the High Court, and justice is provided. But this article is speaking about the weakness of it, and that happens to be frivolous public interest litigation, and that is why the emphasis was on the weaknesses. Now let's look into the next article. This article is taken up from Deccan Herald. As we have told you, we have taken up a couple of important new initiatives, and one such initiative that we have taken up is with respect to the articles that we are sourcing from the the articles that we are sourcing from the Deccan Herald. This article primarily goes on to say melting Jammu and Kashmir glaciers threaten water supply and biodiversity. What is this article speaking about? Increasing cases of the glacier melting. So whenever there is increasing cases of glacier melting, what are the likely consequences? One, the water supply will reduce. Why? That is because of excessive melting of the glaciers. What used to generally happen is during the winter season and during the early Jan and February, what you will have is the glaciers, these glaciers that are formed, and ultimately during the summer these glaciers used to melt, and this used to provide irrigation and drinking water facilities to the people in that particular area. Now that the glaciers are even melting during the winter season, this could ultimately reduce the water quality and also quantity for the people in that particular area. So what is the major issue? This could threaten water supply. They will not have water for the irrigation purposes, agricultural purposes, and also for the drinking water purposes. And these glacier melting and the water that is restored is also required for the industrial activities as well. Now industrial activities will not take place as well. Agriculture will reduce, and all this will significantly impact the people in that particular locality. So the impact is basically that there are people who are dependent on it, on the agriculture, on the drinking water front, and now if there is excessive drinking water, these people will start facing the impact of the glacier melting. Added to it, whenever we speak about biodiversity, there are a couple of species. Let's say for example we have the snow leopard, or let's say for example we have the tiger. These species are also dependent on the glacier, but if ultimately there is excessive glacier, the biodiversity could also be threatened as well. Added to it, we have the albedo effect. What is this albedo effect? Because of the glaciers that are present, they would be able to reflect the solar radiation. So because they would be able to reflect the solar radiation directly, so they will not hit the earth. The minute you have the radiation, it is reflected back into the space. But now if there is more solar radiation, glacier melting that takes place, this will further increase the glacier melting, and ultimately what you will see is more water that is melting, more glaciers and ice that is melting. This could also lead to increase in the sea water as well. These are some of the drawbacks when it comes to the glacier melting. So what are the measures that we may have to take? One is with respect to growing of more trees in that particular area. So what we have to control is on the deforestation. Because of the deforestation and the anthropogenic induced factors, what we are witnessing is excessive climate change related factors influencing the region. So if we are able to plant more trees and conduct in deforestation activities, we have to ensure that such activities increase over a period of time, ultimately reduce these kind of issues. Added to it, we also have to use sustainable agricultural practices, and we have to upkeep with the international agreements. Let's say for example, we have the Paris Agreement. The Paris Agreement was signed in the year 2015. One of the important parameters of this Paris Agreement that was in 2015 is to reduce the temperature and keep this temperature within 1.5 degrees centigrade or maximum to about 2 degrees centigrade. For this, what we have is the nationally determined contributions. Most of these nationally determined contributions are not binding, but they are voluntary, and as a result many countries are not even following it. So these nationally determined contributions, which are as part of the international commitment, they should also be upkept as well. They should also be followed and implemented as well. And at the same time, some of the adaptive measures, like for example, the government of India has taken up many measures. We have to ensure flood controlling measures are in place, that these glaciers do not melt over a period of time. So anthropogenic induced factors should not happen in a specific region. Pollution should not take place in that particular area. There should be a no-man zone in all these glaciers. If such measures can be taken up, this will also reduce the glacier melting, is what is this article all about. Now let's look into the next article. And this article here is primarily speaking about asteroid Psyche. This is very important from your GS paper 3, which is science and technology. So the NASA, that is happens to be a primary space agency of United States of America, has come up with a program called a Psyche probe, which happens to be a probe to understand the mechanism of this particular asteroid. So the Psyche probe, folded inside the cargo bay of SpaceX Falcon Heavy rocket, blasted off from NASA's Kennedy Center, and this spacecraft, roughly the size of a small van, is due to reach the asteroid in August 2029. And once it reaches, what does it do? It tries to understand how exactly the Earth was formed. So this asteroid measures roughly around 173 miles across its widest point and resides on the outer fringes of the main asteroid belt between planet Mars and the Jupiter. So this particular mission will basically study about this asteroid, which is between the Mars and the Jupiter. The spacecraft was due to be released by rocket's cargo bay by 5 after the launch, then took 2 hours. And basically what is the objective of it is believed to be largely consisting of this particular asteroid is basically into understanding how the solar system was formed, how the solar system works, and how the solar system orbits around the sun. It is about understanding the gravity, the magnetic properties, the composition, and everything about this asteroid. So how exactly the Earth originated, why the temperature fluctuations happen, what are these changes that the Earth will witness in the near future, what could be the likely consequences, how did the Earth originate, what is the presence of the different kinds of metals that are present in this particular asteroid, will all be taken into picture, and ultimately they will come into a conclusion. So the Psyche mission has nothing to do with space mining. Its objective is to gain insight into the formation of the Earth and other rocky planets that are built around cores of molten metal. Earth's molten center is too deep and too hot to be examined directly, which is why they are taken up this question. They have taken up this mission. So basically this happens to be a mission to study about asteroid Psyche. It is this that we have to understand with respect to this article. So this is it from today. If you are liking these initiatives, please do like, subscribe to our YouTube channel, and also share it with your fellow aspirants as well. Thank you for watching. All the best.